Good morning. I'm going to call the House Judiciary Committee to order. Madam Clerk, will you please call the attendance?
Chair Lightfoot.
Here.
Representatives Begol. Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter.
Here.
Hope. Here. Green. Present. Scott. Madam Chair, you have 10 members present. You do have a quorum.
Thank you, Madam Clerk. Rep. Schutte moves to adopt the minutes from March 4th. Hearing no objection to the minutes are adopted. No absent members. Okay, we are going to jump right in today. We kind of have a tight timeline again today, but we will call to the testimony table Rep. Harris regarding House Bill 5281. Also wishing to speak with Rep. Harris is going to be Judge Michael Warren, who is on Zoom. Judge Warren, are you there? Oh, you're on mute.
Okay.
Okay.
I'm here now.
Judge Warren, if you can just, I just want to make sure you were on. Rep. Harris is going to do a quick overview real quick, and then you will be right up next, okay?
Fantastic.
Thank you, sir.
Well, thank you, Madam Chair, Vice Chairs Begol and Carter, and members of the House Judiciary Committee. Thank you for the opportunity to testify before you today. House Bill 5281 addresses the growing use of what is known as third-party litigation funding, or TPLF. This is a practice where outside investors provide money to finance lawsuits in exchange for a share of the settlement or the judgment. Let me begin by being clear what this bill does not do. This bill does not prohibit litigation funding, it does not prevent anyone from filing a lawsuit, and it does not stop a plaintiff from seeking financial assistance while a case moves through the courts. What this bill does is require transparency, reasonable guardrails, and clear rules so that Michigan's justice system continues to operate fairly and in the open. TPLF currently functions with minimal oversight in the state, limited safeguards, and a lack of transparency. This situation results in various challenges within Michigan courtrooms, and 5281 aims to ensure that litigation decisions remain with the parties and their attorneys. You know, when financial interest can participate in lawsuits without disclosure, it takes legitimate concerns about fairness, conflicts of interest, and public confidence in the judicial process. And today you'll hear more testimony in detail about how litigation funding works in practice, how it can affect plaintiffs, businesses, and the court system, and why other states have already acted to put reasonable guardrails in place. House Bill 5281 follows that same common sense approach. The bill requires disclosure of litigation funding agreements so courts and parties understand who has a financial interest in the case. It establishes reasonable limits on financial terms to protect the person bringing the claim. It makes clear that outside funders may not direct litigation strategy or interfere with the attorney-client relationship. And it includes protections to ensure that foreign countries or entities of concern cannot secretly finance litigation in our courts here in Michigan. Now, you might hear concerns that this bill limits access to justice, and I respectfully disagree. Access to justice means the ability to bring a claim and have it decided fairly under the law. It does not require secrecy, and it does not require that outside investors operate without oversight. You may also hear that this is simply a matter of private contracts and the state should not be involved. But when financial agreements directly affect cases being heard in our courts, the legislature has a responsibility to ensure that transparency, fairness, and integrity in the judicial process continues. We regulate other financial industries where large amounts of money can influence outcomes, and the same principle applies here. You might also hear that this is not a problem in Michigan. The reality is that without disclosure requirements, we have no reliable way of knowing how often litigation funding is being used or under what terms. This bill does not assume wrongdoing. It simply ensures that the practice operates with clear rules that protect everyone involved. The states across this country, both Republican and Democrat, have adopted similar reforms, recognizing that litigation funding should not occur in the shadows. And at the end of the day, our court system exists to resolve disputes based on facts and the law. House Bill 5281 keeps litigation funding available They'll make sure that it happens with transparency, accountability, and fairness. So thank you, Madam Chair, and I appreciate the committee's time, and I look forward to testimony from those here in support of the bill. And as you see, we have Judge Warren, and good morning, Judge.
Good morning. Madam Chairman and Vice Chair and members of the committee, thank you so much for the opportunity to address the committee today on House Bill 5281. And I'll be brief as possible to respect your time, but also I've got 2 preliminary injunctions waiting for me and some other things. So I have to get back to my docket quickly, but I am Judge Michael Warren of the Oakland County Circuit Court. I've been a judge for 23 years. I presided over 375 jury trials and thousands of cases. I presided over a general civil docket, a criminal docket, a family law docket, and I currently have a business court docket. I have a couple of caveats to my comments. First, I'm offering a broad bird's eye view. I'm not able to dig into the weeds too much. And second, I personally have no objection to third-party litigation funding. It's an odd concept to many, but lawsuits are an asset, and assets can be bought and sold, financed and traded. The key is to ensuring that each transaction is done above the board in a commercially reasonable way, in which Adam Smith's invisible hand can benefit those involved in the transaction, as well as the broader society. With that in mind, I think third-party litigation reform makes sense from 5 different perspectives. First, consumer protection. There's been a long-standing practice of ensuring that litigants understand their rights. This is especially true for litigants who are facing some of the most difficult and traumatic circumstances of their life due to no fault of their own. When faced with these circumstances, having clear, standard, and easily understandable terms and cautionary warnings is essential. Unfortunately, there are unsavory characters and large companies that like to prey on the vulnerable, and this reform should assist in fending that off. I teach consumer protection and securities law at Wayne State's Mike Illett School of Business in the umbrella of the business law program or class. And that law is designed to ensure, so consumer protection securities law is designed to ensure that consumers understand exactly what they're getting without false promises, key omissions, confusing language, and fraud. There is a parallel to these protections here. There's a trend of ensuring greater transparency in consumer protection, and that has been wide and deep, and it's been expanding to include consumer, legal, and the medical fields. This is just the next logical step. The second perspective is ensuring no conflicts of interest. Because the identities of third-party financiers are undisclosed, whether a particular funder in a specific lawsuit creates a conflict of interest with opposing counsel, members of a jury, or even the judge cannot be ascertained. If after the fact a conflict is revealed, it destroys the integrity of the whole process, even if there was no wrongdoing. It's the appearance of impropriety. The third perspective is that disclosure enables both sides to realistically assess the best way to move forward with the case. We already do this in the context of insurance by requiring disclosures of insurance policies. The same should apply to financing. Although I guesstimate that about 98% of my viable business cases settle, sometimes parties are intractable for completely unperceivable reasons, and these disclosures may be essential to resolving at least some of these cases. The fourth perspective is that the rules of court often require courts to shift burdens and to ascertain whether relief should be given in light of the nature of the case and the relative position of the parties. If a seemingly small, lonely plaintiff is actually backed by, a billionaire company, that could change the court's allocation of costs and its decisions on permitting or barring certain types of discovery and who should bear those costs. Finally, I'm gravely concerned that foreign governments or companies could be funding these lawsuits. America's many enemies are looking for many ways as possible to injure America, and this could quite literally penetrate into the heart of justice. I'm unaware of any of this, but it certainly makes sense to not allow that to happen. Thank you for your time. God bless you, and God bless America.
Thank you, Judge Warren.
You're welcome. Am I released?
You can be released unless you want to stay on for questions, but we're good.
If it's okay with you, my docket has been patiently waiting for me.
Yes.
So I'm going to.
Okay.
All right. Thank you all
you.
very much. Everybody have a blessed day.
We do have a question right now, Representative, if you're ready for at least one. And I know there's more people that want to speak, but we'll just at least get started. Rep. Breen.
Thank you, Madam Chair. I think I might be the only one up here, other than maybe Rep. Wozniak, who's handled litigation from both the employer and large insurance companies as well as plaintiffs. So this is generally how it works, because we've been talking broadly about class action lawsuits, which I know Michigan has benefited from with the opioid settlements. Millions of dollars have come back into the state because of this horrible epidemic we've had. But we haven't talked at all about the consumer side here. And that, so a person is injured, hypothetically, maybe they were visually impaired and slipped in a bathroom, and they can't work anymore. So the kids are hungry, they're unable to work, the rent is due, maybe their car was beat up in an accident. How do they live while they've got a lawsuit pending? And this is where third-party funding comes in.
Sure.
And this is done on a contingency basis. So if the person loses their lawsuit, they get nothing. It was a risk people take. Now, on one hand, you are asking the plaintiff to disclose all this information, but however, this can also reveal trial strategy. What defendants will do is they will stretch cases out for years, knowing the financial limits of that claimant and that they can get them to settle for pennies on the dollar, whereas the defendants aren't forced to disclose what their claim reserves are. So the defendants, large companies, corporations, they have a lot more at their disposal. So I would like to know, why is it fair for the plaintiff to have to be disclosed? Because why is this even useful to the defendant, whereas the defendants aren't required to disclose what their reserves are, unless it is through discovery? And I'm wondering, so why is it fair? Why is it one-sided? And have you considered looking at the Louisiana model, because that would be much more palatable?
All right, I'll try and answer these in pieces. Number one, it's, I think disclosure and funding comes into play no matter how this goes, right? And transparency, if a defendant or let's stick with your example of a defendant. So if you know that an insurance company or business or what have you, they're funding their own, right? So you know that, this insurance company or this billion-dollar business has their own funding. What we don't know is who the backer is in third-party litigation funding on the plaintiff, correct? The judge doesn't know. The parties in the case don't know. So that's currently the issue.
But that's not true, though.
Okay,
the judge knows. The judge reviews these agreements. They're able to do that right now. Claimants know. In
federal court, yes.
But judges are allowed, as of now, even to review the agreements.
Okay, not to my knowledge.
Okay, maybe we can talk about this offline, and maybe.
Yeah, and we have a lot more testimony, Rep. Breen. We do have to be out of here shortly after 11:30 today, so I want to go ahead and get. We'll do questions at the end. Let's get the testimony done for this bill right here. And Representative, you can just stay there. Sure. But I will call up Zach Rudat of the Michigan Alliance for Legal Reform, wishing to speak in support of the bill. And Zach, just so you know, we have 3 other people beside you that are already scheduled to testify. So if you could keep it kind of short, that would be great. Thank you.
All right, I'll try my best to be brief. Good morning, everybody. Chair Leitner, Vice Chairs Begole and Carter, and members of the committee. Thank you for having me today to host this important discussion. As Chair Leitner said, my name is Zach Rudat, and I'm the Director of the Michigan Alliance for Legal Reform. The Alliance is a coalition of 45 Michigan associations and employers dedicated to reining in lawsuit abuse and restoring balance and fairness in Michigan's legal system. I'm here today to testify in support of House Bill 5281, which seeks to place common sense oversight, guardrails, and transparency measures for judicial financing practice called third-party litigation funding, or TPLF for short. TPLF is a fairly new judicial financing system with a pretty simple premise. Outside investors, oftentimes hedge funds, finance lawsuits in exchange for a cut of the final awards or settlements. It's estimated that TPLF is used in 30% of America's infringement cases, with nationwide investments totaling an estimated $15.2 billion. The word estimate is what really brings us here today. Since TPLF is so new, and it operates with virtually no oversight, guardrails, or transparency in many parts of the country, including here in Michigan. This creates a host of problems in our courtrooms. For starters, a lack of disclosure means TPLF can operate in a courtroom without the judge, jury, defendant, or even the plaintiff themselves knowing. Even if a party in lawsuit discovers TPLF is being utilized, the funder themselves may still be unknown. Even in cases where plaintiffs are aware TPLF is being utilized, the significant price tag is not always clear up front. In Michigan, there are no limits on what the financer can charge for their investment. This can create predatory scenarios where the plaintiff technically wins in court, but receives little to none of the award because the financer's cut is so large. Due to the lack of TPLF guardrails in Michigan, financiers can discreetly put their thumbs on the scales of justice. Financiers can influence the legal strategy of a lawsuit they're financing, pressuring a plaintiff to settle sooner or later than they wish, or hold out for the unknown. From a larger perspective, financiers can quietly transform our legal system, creating courtroom backlog, discreetly reshaping legal dockets, and operating in the shadows of the system itself. This lack of sunshine creates a significant national security risk, as Judge Warren touched on earlier. So for example, if a foreign adversary is on the receiving end of a tariff, this creates an opportunity for them to finance lawsuits in Michigan that undermines our economy. By funding lawsuits behind the scenes, adversaries could also potentially gain access to sensitive information through the discovery process, all without their involvement ever being disclosed. Without common sense oversight, guardrails, or transparency measures, bad actors can use TPLF to undermine the integrity of our judicial system, turning TPLF into an unregulated investment tool. House Bill 5281 addresses these concerns without prohibiting TPLF. It requires funders to register with the state and disclose with parties in a lawsuit, ensuring TPLF operates with transparency. It places a cap on funder earnings, ensuring plaintiffs themselves receive the compensation they deserve. It prohibits funder influence on the lawsuit, ensuring justice, not dollars, is the guiding compass of our legal system. And it bans foreign adversaries from funding lawsuits, protecting national security interests across our state. Some voices opposing TPLF reforms are the same folks who actually profit off of today's lack of transparency and guardrails. Some will argue this isn't a problem in Michigan, and they'll be able to cherry pick rosy examples of TPLF in action because they're entitled to information that the public is not. But if TPLF in Michigan isn't a problem, I would argue transparency shouldn't be either. Proponents will try to argue that TPLF reforms limits access to justice, but that is simply not true. This legislation does not prevent anyone from filing a lawsuit, nor does it ban TPLF itself. This bill merely stops bad actors from abusing the system at the expense of plaintiffs and small businesses. I'm not here to testify TPLF is a problem. The lack of oversight, guardrails, and transparency is. Some may argue that 36% rate cap in this bill is too low. I will note that Michigan's criminal usury rate is 25%. Proponents will try to argue these reforms infringe on First Amendment rights, but again, not true. This bill explicitly protects a nonprofit's ability to fund a lawsuit and offer pro bono representation without disclosure or registration, as long as they aren't collecting a cut of the award or settlement beyond attorney fees. This legislation only impacts financiers if they intend to profit off of their investment. These reforms aren't controversial or partisan. As of January, 19 states across the country have enacted TPLF reforms, including states as blue as California, Illinois, and New York, states as red as Oklahoma, Montana, and West Virginia, and our neighbors Wisconsin, Indiana, and Ohio. 19 additional states, including Michigan, have pending reforms before their legislatures. By enacting common sense, transparency, and guardrails for third-party litigation funding, we can bring more integrity to Michigan's legal system. Thank you for your time, and I welcome any questions from the committee.
Thank you, Zach. You can stay there if you want. Next up, wishing to speak, supporting the bill, Phil Goldberg of the American Tort Reform Association. Okay, Phil, you have the floor.
Great, can you hear me?
Yes, thank you.
Great. As you said, my name is Phil Goldberg, and I'm testifying today on behalf of the American Tort Reform Association, which is a coalition of businesses, municipalities, and associations that share the goal of having a fair, balanced, and properly functioning civil justice system. I also do work with the Progressive Policy Institute, including publishing an op-ed on concerns of litigation investing has on courts as a government service and on the parties themselves. ATRA supports this legislation because it helps address some of the most prevalent abuses of litigation investing that we have seen over the past 20 years. Before that, outside investing was generally not allowed. The civil justice system was seen as a place to resolve disputes. But as you've heard, today it is one of the most rapidly growing investment sectors. You have hedge funds, sovereign wealth funds, foreign businesses, all buying into lawsuits for financial return. And they, as you've heard, have an estimated $16 to $20 billion invested in U.S. litigation, which is expected to double over the next few years. So this whole industry has gone from 0 to 60 with no rules of the road to protect the integrity of the civil justice system as a public good or the parties in their desire to resolve their disputes. Plaintiffs and defendants now have extensive experience with litigation investing. And we are seeing firsthand from both sides of the V how litigation investing, without, as we just heard, these kind of guardrails, take advantage of the parties and take control of the litigation away from them in the courts and give it to the outside investors. Nationally, these investors, not the parties, are often controlling which cases are brought, how long they are pursued, when they are settled, and for how much. And this is being done largely without transparency, certainly to the courts and the defendants, but also in the mass tort cases, plaintiffs whose investors buy into a law firm's portfolio of cases without out of line of sight of the individual plaintiffs themselves. And these are incredibly sophisticated documents. And this bill addresses those things. And let me just share with you in the next couple moments what we are seeing especially from the commercial litigation side, and why this is so important. From the mass tort perspective, about 2/3 of the money is going into these what we are called portfolio loans. They are building litigations that are just simply too big to fail. They advertise with plaintiffs, they pay scientists, they pay lawyers, and up to half of the plaintiffs have no basis for being there. They can't show they use the product or suffer the harm. They literally just click through an ad, and no vetting was done to make sure that their claims are valid. They just get filed. So the goal here is by the funders is to create lucrative lawsuits, not necessarily good lawsuits. And that's a key difference in why this is a problem. The second thing we're seeing is that this funding is interfering with the parties' decisions in their own lawsuits. Some of the agreements, and we've seen a number of them, give direct control of the litigation to the investors and away from the individual parties. We saw in a very well-known case in the last couple of years, Cisco brought an antitrust case against some of their meat suppliers. And they wanted to get to a settlement, thought it was fair. They thought they could end the antitrust activity as they saw it, and they went to enter settlements. And when Cisco and the funder said, no, that's not good enough for us. And today, the litigation is still going on, and the funders actually replaced Cisco in the litigation because Cisco said, we're out. We don't want to be part of this anymore. And the court said it had to let it happen because that's what the document said. But it also took Cisco's lawyers to task for doing the bidding of the funders and not their client, Cisco. And if a company like Cisco has no ability to protect itself, certainly mass tort plaintiffs don't even know who their lawyers are. Their lawyers couldn't even pick their plaintiffs out of a lineup, certainly have no shot at having any control over their litigation. We're seeing foreign companies finance lawsuits for strategic goals. The GAO report recently came out showing how sovereign wealth funds are now investing in U.S. litigations, including from the United Arab Emirates. Former U.S. Attorney General wrote in the New York Times about a case from a foreign computer chip manufacturer that funded litigation in the U.S. against Intel to get Intel's intellectual property. We've seen a Chinese firm financing IP cases in the United States, with the former acting director of the U.S. Patent and Trademark Office calling this development, quote, our worst fears confirmed. And the chief of the Foreign Agents Registration Act at DOJ in the previous administration said that foreigners are using litigation investing to gain access to sensitive U.S. information and sow discord in the American industries. And as we heard the judge talk about recently, the presence of this makes it more difficult for them to administer their dockets, from settlement conferences to making sure decision makers are there, to determining their conflicts and recusal issues, to assessing the party resources for discovery, cost allocations, sanctions, and also to manage privileged documents, which is an important thing that this bill does, is it says when documents are from trade secrets to plaintiff health records, they can't be shared with funders, and that's important. And then on the consumer funding side, I just did a search this morning, found out that you can get from $500,000 to $250,000 as soon as tomorrow for your lawsuit. These are like mortgages, the size of these loans, all being done without some basic protections for consumers. And these also interfere with the ability of the parties to reach reasonable settlements, because if the plaintiff owes a lot of money back to the funder that helped them, and that may be a very useful, important part of the process, but it makes it more difficult to reach reasonable settlements if they're not going to get anything, and all the money is just going to go to the funder. So this sets common sense limits for that as well. And so for those reasons, ATRA very much supports this bill and encourages and urges the committee to pass it. Thank you.
Thank you, Phil. Next up, supporting the bill, wishing to speak on Zoom is Mark Benrens from the U.S. Chamber Institute for Legal Reform. Mark, you have the floor. If you can keep it short and sweet, that would be great.
Yes, thank you very much for members of the committee. I'm Mark Behrens. I'm here on behalf of the U.S. Chamber, and Phil and the other witnesses, I think, have done a terrific job laying out the case why reform is needed. I'm going to just very quickly hit on some of these points and maybe add to them on why the bill provides for no funding by foreign adversaries. That's important because we're seeing there's a threat that foreign adversaries may target U.S. businesses in litigation to saddle them with extraordinary cost and hurt their competitiveness. The former U.S. Attorney General wrote an op-ed where, in fact, he said, by targeting U.S. innovators and companies in critical industries, foreign-funded lawsuits drain time and resources that could be dedicated to producing cutting-edge technologies that will keep America safe and prosperous. Our allies or our enemies can use our legal system to weaponize the courts against us. There's also a concern that countries like China could use litigation funding to access trade secret information that is routinely provided in the course of discovery and civil lawsuits. In fact, we have seen a handful of cases that have been funded by a Chinese entity. And a former acting director of the U.S. Patent and Trademark Office said, this is our worst fears confirmed, because obviously any businesses from China have direct ties with the Chinese Communist Party. So the bill would protect American interest on both of those fronts by preventing foreign adversaries, only our adversaries, from funding lawsuits in the United States, and protection of trade secret information that is exchanged in discovery. The bill also provides that the funder cannot make litigation decisions. This is a fundamental ethical duty that all lawyers owe to their client, to put the client's interest first. Every lawyer has that obligation. The client must come first. And litigation funding creates a tension between that fundamental relationship between the attorney and the client, because it's naive to think that somebody that may provide hundreds of millions of dollars to funded plaintiffs' firms, and there are firms that have taken hundreds of millions of dollars in some cases through litigation funding, that somebody that would provide that level of funding to a firm would simply provide it and say, good luck with the case, let us know how it works out. That's naive to think that anybody investing that kind of money is just going to give free rein to how the litigation is handled. What's the old saying, that the golden rule, that the person with the gold rules? Well, in this case, the person with the gold is the funder. And that's going to put the attorney in an ethical dilemma on whether to respond to the funder's interest or to the client's interest, where their ethical duty is. And there's two ways that this can hurt consumers. One is, and there we've seen, they're going to be very different scenarios, and we've seen examples of both. One is that where a funder is trying to flip a case and get cash quickly, the funder may pressure the lawyer to reach an early settlement because they're trying to get a quick return on their investment. They don't want their money tied up in years of litigation, and there could be pressure on the lawyer to take a settlement now when it may be in the client's interest to delay the case and pursue litigation through to the end. Conversely, there may be funders that are looking for a nuclear verdict. They may have funded a lot of cases, and where it may be in the individual consumer's case, to get a recovery and assure living expenses are covered, ensure that family members are covered if there's an event of a serious injury or death, to protect the family. That may not be in the funder's interest. The funder may say, I want to roll the dice and try to get a nuclear verdict here. Again, putting the funder's interest diametrically opposed to the consumer's interest. And the bill protects the consumer in both of those circumstances by saying, consistent with every lawyer's ethical duty, that the consumer comes first. And then finally, disclosure of the funding agreement. That is important to know that these rules are not being violated. It's also important for courts to know who is at settlement. So when they go to settlement a case with the plaintiff's attorney is sitting around the table and they think that a case is settled, the judge doesn't want to find out then that, oh, the plaintiff has to say, let me go make a phone call because I need to go clear this with an investment banker in New York City or in London. So we don't want that in Michigan, and the bill would prevent that. And I think that's probably one of the reasons why you heard such powerful testimony earlier from a trial court judge in Michigan, because this complicates their ability to settle cases and move their docket. And then lastly, there was a very good question raised about disclosure and the impacts on cases. One, disclosure will not prevent access to courts. It will not prevent funding. It's a very modest step that many other states have done. And second of all, insurance agreements are already provided. So on the defense side, if there's an automobile accident, let's say in Michigan Court Rule 2.302, which is similar to Federal Rule of Evidence 26, was amended in January of 2020 to provide that a defendant has to automatically provide the insurance agreement information to the opposing side in a lawsuit. So the plaintiff knows how much the defendant has in the case. And defendants are not trying to get this information to find out how much money the plaintiff has, but we're trying to find out if there are conflicts here and if any of these horror stories that we've seen in other cases are coming up, that courts know about it and parties know about it so that they can take appropriate measures to stop those things from happening. Thank you for your support of this bill, and I'd be happy to answer any questions.
Thank you, Mark. If you want to just hold, that'd be great. Next, we're going to move on to Adam Ethington of the National Insurance Crime Bureau via Zoom, supporting the bill, wishing to speak. Adam, are you ready? If you can keep it short and concise, less than 5 minutes, that would be ideal.
Absolutely. I'll be very brief. Thank you, Chair. National Insurance Crime Bureau is a national century-old not-for-profit organization supported by approximately 1,200 property and casualty insurance companies, including many who write business in the state of Michigan. Working hand in hand with our member companies and Michigan state and local law enforcement, we help to detect, prevent, and deter insurance crimes. Insurance fraud is not a victimless crime. A 2022 study placed the total U.S. insurance fraud in the United States at $308.6 billion. Fraudsters will exploit every avenue, forum, and opportunity to bilk consumers and their insurers to line their own pockets, which ultimately increases costs for everyone. Unfortunately, the courtroom is not immune. Fraudsters and their affiliates have engaged in a predatory and abusive litigation tactics and employed tools to advance and conceal their aims. NICB is concerned that absent additional transparency and accountability, litigation financing can serve as a facilitator for fraud. For an example, NICB assisted the U.S. Department of Justice in their investigation and prosecution of a massive trip and fall fraud scheme in New York, which defrauded businesses and their insurance providers more than $31 million. This organized insurance fraud scheme included deliberate unnecessary surgeries performed on victims simply to drive insurance claims and lawsuits upwards. The surgeries, as well as other medical procedures, were funded by litigation financing companies. The financiers also paid the fraud scheme organizers and participants referral fees for each patient who signed a funding agreement, charged the patients, who were overwhelmingly low income, absurdly high interest rates, and the majority of the proceeds awarded in the fraudulent lawsuits went right back to the financiers themselves. A new joint analysis conducted by NICB and Forewarn has uncovered a strong connection between TPLF and excessive litigation instigated by fraudulent digital tactics, opportunistic marketing. In one case, a single funder supported 13 law firms that targeted 66 different insurers to drive claims litigation and maximize the investor's return. NICB's assessment shows that funders targeted U.S. insurers at a significant rate, with nearly 75% of insurance companies assessed being directly targeted by opportunistic litigation marketing campaigns. The bill, as you know, requires attorneys and plaintiffs to disclose any third-party funding agreements to the court and all other parties in the lawsuit. As others have mentioned, it also prohibits funding from foreign countries of concern, thus strengthening accountability over otherwise opaque foreign investment in our justice system. And I'll skip a few other things in the name of time, but we just want to let you know that NICB strongly supports HB 5281. It's part of an ongoing effort in many states to help bring some transparency to this process. And I'm happy to stick around and answer any questions.
Thank you, Adam. Well, next up, we have Rep. DeBoyer with a question.
Thank you, Madam Chair. I'll be as brief as possible. Couple quick things. The first thing is I realize, and you're very clear about that, the bill does not prohibit third-party funders. But I'll be honest with you personally, what has been created because of this, and give the credit to the lawyers and the capital investment people. This is nothing more than venture capital for lawsuits. That's really what this is. We have a thing called contingency fees that allows for a lawyer to do a case without payment, depending on outcome. We now have an individual on the back side of that, which I would argue, much like venture capital in the real world, it's encouraging a behavior that otherwise may not occur because no one believes it to be valid. Secondarily, is there any prohibition that says, because really we're turning this into a commodities market. That's really what's happening here. Yes, no, right? Win, lose. Is there any prohibition that says you can't have venture capital coming in on both sides of a case? The same venture capital? Because you could have a scenario where there's a counter lawsuit, right? And now all of a sudden you have one investor on both sides who's going to take a piece of profit. That's a horribly dangerous thing to our judiciary system. It was never designed to operate this way. And now we see entities looking at this as a for-profit enterprise as opposed to a place where you can go and get justice. So it might be just a consideration of an additional prohibition that should be in that bill, because I didn't see it as I read through. But the idea that you could be on both sides is unbelievable to me. So please, thanks.
Yeah, and I don't know if maybe one of our attorneys online have any experience with that across the nation or what they've seen.
We'll have to come back to that, I guess. Next up, we have Minority Vice Chair Carter that has a question.
Thank you, Madam Chair. My colleague, would you be interested in looking at some amendments to make sure that injured plaintiffs, and I had to write this down, I've been waiting a while, are not at a direct disadvantage by giving defendant corporation counsel information about the litigation financing agreement? And the reason I say that, unlike many, I've worked in many a courtroom, and everybody's not suing for proprietary information. It may be somebody that's suing, and I've watched corporations or entities wait them out because they knew they didn't have any money. So would you be agreeable to even entertain an amendment? We can talk about it offline.
Yeah, I'm always happy to talk.
Okay.
It's but we've also seen this have the opposite effect as well, right? It allows the plaintiff to do the exact same thing and drag it out.
Well,
but I'm absolutely happy to talk to you.
And we talk about, you see the every lawyer was on the radio on the way up here, no cash until you win. But
Right.
we got to figure out a way to kind of even the field. Thanks.
Yeah.
Thank you, Representative. Representative Schutte.
Thank you, Madam Chair. So this legislation puts some guardrails, frameworks, transparency regarding third-party litigation funding. Are there, and we've mentioned some steps other states have taken. Have any states outright banned the practice?
I'll jump in on that one. Oh, sorry. None as of today. There's been 19 states that have enacted something on this, and it can vary in degree of strength. Some very much mirror this. Some are stronger than this. Some are weaker than this. But again, I'll just reiterate, this reform has been pursued across the political spectrum. States as conservative as Montana, West Virginia, Oklahoma, progressive as California, Illinois, New York, a lot of our neighboring states. We've seen reforms on this on a number of fronts. No state has outright banned it, and that reform can vary from state to state, but nobody has outright banned it yet.
Well, I appreciate that because, I mean, you look at Russian oligarchs funding cases where you're involving sanctions against the United States, there's serious national security concerns with third-party litigation funding. So thank you.
And I'll just add in, I first heard about third-party litigation funding 2 or 3 years ago at an intelligence briefing that I still go to annually. And this was brought up by one of our federal intelligence agencies under a previous administration that had major concerns on how this affects our country with foreign countries of influence. So it's they've seen the ability for not only countries like China to use the information to produce copies of technology that we've developed here in the United States, but also some other countries that have played into whether it's stealing trade secrets or just bogging down our court systems in a vindictive manner. So, yeah, I do think it's an issue.
Thank you. Rep. Wozniak.
Thank you, Madam Chair. For you, sir. It states in Section 7 that the insurer, for any insurer that has a duty to defend, when does that duty arise?
That might be a better question maybe for the gentleman from the insurance group, if he's still on the Zoom.
Okay.
I might direct that to him.
Well, that's right. Well, it gives the impression that it's whether or not there's a litigation funding contract or not. So that was my question. Second, in how many states that you've mentioned is the consumer litigation funding inadmissible as evidence?
I'd have to follow up with you on the exact number on that one specifically. I know that 19 states have enacted something. I just don't have the breakdown on that specific piece of the policy or the reform state by state. But we can certainly connect afterwards with that information.
Thank you.
Thank you. And real quick, Rep. Breen.
Thank you, Madam Chair. I have some yes or no questions. Have you gotten a cost estimate from DIFS as to the implementation of this? 2, have you considered any amendments that would make this fairer? Because an insurance agreement, which was mentioned earlier by one of the testifiers, that's about the policy limits. That is not the same as reserves. So if we're talking about the ability of parties to continue on with litigation, it is not the policy limits which affect this, but how much companies have in insurance reserves that will show how far and how long they can wait a case out, which is exactly what you're asking for from the plaintiff. The last question I have is, Judge Warren testified that he is not seeing any evidence of foreign interference with third-party litigation funding in Michigan. Have you seen any evidence of that?
Great questions. So, number one, I'll always talk. If you have suggestions, I'm happy to hear them, especially if it's, you're an attorney, I'm not. So if you have specific legal things that you think that we can chat about, I'm happy. What's that?
Make it fair.
Well, I do think it's fair. I think right now it's unfair, but we can talk more about that. I think, in the political spectrum, we've all asked each other to make, disclosures on where our finances are and so on and so forth, because we think it's important, right, for that transparency and disclosure. I think our court system has the same concerns. So I think making things transparent is not an evil thing. Nope. I think it's a very fair thing.
As long as it doesn't reveal trial strategy.
Okay. Well, I think we have to cut this off because we have we need to vote on another bill. We can come back and do more testimony if we want. I do have numerous cards of support, not wishing to speak, from all kinds of groups, realtors, petroleum association, et cetera, but there's numerous. The clerk will put them on record as well in support, and they will be reflected in the minutes. And yeah, there's also a couple in opposition. But with that, thank you, Representative. Thank you, Zach. Thank you to all the people that were speaking. Next up, we're going to go a little out of order. We're going to call up Rep. Bruck right now to speak to House Bill 5465 in regards to crimes, trespassing, prohibition against entering key facilities. One moment. So before we take up your House Bill 5465, we are going to lay out an H1 substitute. I'm going to move the H1 substitute, which would allow an energy storage system to qualify as an electric utility facility, which already qualifies as a key facility. So it's just making clarification in the bill. With that, Madam Clerk, will you please call the roll on the H1 substitute?
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
Yes.
Hope. Yes. Breen.
Aye.
Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you, Madam Clerk. Well, Representative Bruck, you can speak to the H1 substitute now to House Bill 5465.
All right. Well, thank you, Madam Chair Lightner. It's great to be here today. I thank you for the opportunity to speak on 5465. As you may know or not know, this is part of a much broader, comprehensive package called the Shield Michigan Package regarding drone and critical infrastructure, security, and public safety and drone mobility, of which there's 14 other bills. So this is one bill out of a 15-bill package, of which 2 of your committee members are also on that package, so I appreciate their support as sponsors. Thank you to the committee for hearing this today, as we'd like to move the entire package. House Bill 5465 amends PA 328 from 1931. It really, as we were looking at this, the SHIELD package and how do we protect Homeland Security, how do we ensure that what we're doing is tangible and does the right intent, we looked at key facilities, and there was a lot of outdated and things that just weren't there technologically many decades ago. One of those within the current legislation, or PA 328, is a requirement for a complete fencing around the structure or around the facility. And so as we spoke with the railroads, that was actually a real problem with them. Number one, it was very simple. In the old bill, it simply says railroad switching yard. That's all it says. And then there's a requirement for the fencing. So it really narrowed the scope. So we expanded, we're able to expand with the help of the MRA, the ability for them to protect themselves and to expand it to their key critical facilities in that department. As well as there was a few other things missing. One was electrical storage or energy storage system. So that is defined in the bill, in the sub. So thank you for adopting that. It revises that and expands that, defines it to what the power producers here in our state need and wanted as far as how do we protect our critical infrastructure. We are, as you know, we sit in a very precarious situation as far as nefarious actors here in our state as well as around the country, and that is the impetus of the SHIELD packages. How do we try to make our state safer for nefarious drone activity from either domestic or foreign actors? And then we also added a couple other things, a data center, as well as the railroad tunnels, which are very important components of our infrastructure. And then a little bit of changes on the signage requirements. But I'd say it's a simple fix to some of the problems, but it helps solidify our SHIELD package and make it stronger and more robust and actually update it to the current structure, that we have in our state that we really need to protect and defend. I'm short and sweet, Madam Lightner. I'm not just a pretty face.
Thank you, Representative. We are I'm going to read out these cards. Not wishing to speak, supporting the bill, Adam Majestic of the Detroit Regional Chamber. Supporting the bill, not wishing to speak, Joe Fedewa from DTE. Not wishing to speak and supporting the bill from the railroads, Jonathan Kuhl, who also submitted written testimony, which the clerk has entered in the minutes as well. But with that, right now, we are going to have a vote on this bill. So Rep. Bagol moves to report House Bill 5465 as substitute H1. Will the clerk please call the roll?
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yeah.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shutey.
Yes.
Carter.
Yes.
Hope. Yes. Green.
Aye.
Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Thank you, Rep. Bruck. You're all set.
Thank you, Chair Lightner.
Next up, we are going to bring up Rep. Hoadley on House Bill 5515. With that, I am going to move to adopt in H1 to House Bill 5515. And my substitute would increase the overall blade length in the bill from 5 inches to 6 inches. With that, Madam Clerk, will you please call the roll on adopting the substitute?
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shutey.
Yes.
Carter.
Yes.
Hope. Green.
Pass.
Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 2 pass. The substitute is adopted.
Thank you, Madam Clerk. Rep. Hoadley, you have the floor.
Outstanding. Thank you, Madam Chair, members of the Judiciary Committee, for allowing me the opportunity to testify on House Bill 5515. This legislation amends Section 227 of the Michigan Penal Code to clarify the definition and restrictions on carrying certain dangerous weapons. Specifically, it updates language around prohibited concealed carry of items like daggers, dirks, stilettos, double-edged non-folding knives, and other dangerous weapons with a blade exceeding 6 inches as per the H1 substitute. With exceptions for hunting and fishing knives used and carried for those purposes. The bill refines the statute for clarity, such as removing outdated or redundant language while maintaining public safety protections and ensuring lawful carry of common tools or knives isn't unduly restricted. It does not broadly expand or restrict rights, but provides clear statutory guidance and reduces ambiguity, I'm having a rough time with that one today, in enforcement, ambiguity. As I'm like that insurance commercial, Bibbity Insurance. Here's a real world example. I had a fisherman come to me with this issue. He's a fisherman by trade and by hobby. He was reading through the state law and he asked me, so if I'm hunting, I can carry my knife with me, but if I'm fishing and I carry a fillet knife, am I actually breaking the law? My interpretation of the current law would be yes. Currently, the Michigan law does acknowledge hunting knives. This statute should be extended to fishermen as well. Chances are, most are breaking the law right now, and they don't even know it. If you hop in your car, go to the lake, you put your fillet knives in your tackle box, and then place them in your vehicle or in that trailered boat, you're unknowingly committing a crime. This bill ensures parity between sports and Michigan law. Ambiguities in the current statute, I did that on purpose, to inconsistent enforcement or unintended criminalization of common items. House Bill 5515 addresses that without compromising safety. And you already adopted the substitute H1 for the clarification of blade length. So with that, if there's any questions, I'd be happy to answer them without any ambiguous answers.
Thank you. We do have somebody wishing to speak and opposing the bill from the audience on House Bill 5511. Cindy Twitchell, representing herself, would like a few minutes to speak. Cindy, if you would like to approach,
No,
stay
no
there.
questions from you. Want me
Just
to
stay
stay
there
there?
and if you would like to take that mic, that would be great. Sorry, I got a little dyslexia or something going on today. 5515.
It's something in the air, Madam Chair.
Cindy, you have
Hi.
the floor. Hi. Thank
Good
you.
morning. Yes, I'm representing myself as one of the people referred to in Article 1, Section 1 of the Michigan Constitution that states clearly all political power is inherent in the people, and also, as every bill and public act starts off with, that it's the people of the state of Michigan enact. So good morning. Today, this committee is being asked to consider a bill that strikes at the heart of one of our most fundamental liberties, guaranteed to the people of Michigan and the United States, the right to keep and bear arms. From Michigan's earliest days as a state, this right has been understood as fundamental. The Michigan Constitution of 1835, adopted before statehood, explicitly protected the right of the people to bear arms. And that protection has been reaffirmed in every constitution since 1850, 1908, and again in our current Constitution of 1963. When we ask what the Constitution protects, we must also ask what the founders understood the word arms to mean. Black's Law Dictionary, first edition, 1891, one of the most authoritative legal references of the late 19th century, defined arms broadly to include weapons carried or held for defense, including military equipment. The definition encompassed items worn for defense or carried in the hand for protection or resistance. Knives and other common defense tools plainly fall within the historical understanding. They were ordinary, lawful implements of personal defense at the founding and throughout Michigan's early constitutional history. To declare them outside the scope of constitutional protection today is to rewrite both history and law. For nearly 2 centuries, Michigan has recognized the right to keep and bear arms belongs to the people themselves, not to the government to grant, license, or withdraw. HB 5515 breaks with that unbroken constitutional tradition. Our Constitution is not ambiguous. The Second Amendment affirms the right of the people to bear arms shall not be infringed. Michigan's own Constitution goes even further, declaring that every person has a right to keep and bear arms for the defense for himself and the state. HB 5515 violates both. This bill does not merely regulate the manner of carry, it prohibits the carrying of common knives, common defense tools, and even licensed pistols in ordinary everyday circumstances. It criminalizes possession in a vehicle even when the individual is traveling lawfully. It restricts carry to one's own home, business, or land, effectively erasing the constitutional right to bear arms in public. The right to keep arms means ownership. The right to bear arms means carrying them in public for lawful purposes, including self-defense. A right that disappears the moment a person steps into a vehicle or onto a public street is no right at all. And we must be clear on a fundamental point of constitutional law. The state cannot license a right and charge a fee for it. A license cannot be used to grant, deny, or confine a right that the Constitution already secures. When the government conditions the exercise of a right with permission, paperwork, or location, especially by confining it
I'm
to
sorry,
private
Cindy.
property.
Can you speak to the merits of this bill in regards to what this one does? This bill right here. You're getting a little off, which I appreciate. I do appreciate your comments, but if you can, I mean, it's literally a 2-page bill.
Right.
Okay, and we need to get on to one more member that's sitting behind you, but if you could kind of condense to the specific of us expanding the language for so people aren't unknowingly, because they're basically what's happening is they're unknowingly breaking the law right now, and we're expanding the length of a knife. That way, more people are covered and are not facing any criminal penalties.
Right. And my point is, based on the Constitution, which you all took an oath to uphold and defend, which protects the rights of the people. This bill, and if I can, I guess I'll go almost to the end of my thing. As elected servants who swore an oath to support the federal and Michigan Constitution, it is your duty to not weaken the rights of the people, but to defend them. HB 55 is an overreach. It is unconstitutional. It places law-abiding citizens at risk of becoming criminals for exercising a right that predates the founding. And even if you just increase the size, putting a limit on the length of a blade of any kind, that's unconstitutional. You do not have that right. A right that must be asked for, confined to one's property, or surrendered at the car door is no right at all. And this body should not be the one to declare it so. For these reasons, I urge you to reject the bill and relook at existing public acts that are unconstitutional and repeal them. This section and all other sections dealing with anything with weapons or arms of any kind should be repealed. They are unconstitutional. Doing so, you will be standing firmly with the Constitution you swore an oath to uphold. And I'll leave you with some words from our founding father, Thomas Jefferson. Thomas Jefferson wrote in a letter to William Johnson, June 12, 1823, "On every occasion of constitutional interpretation, let us carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of trying to force what a meaning may be squeezed out of the text or invented against it, instead let us conform to the probable one in which it was passed." And then he wrote to John Cartwright in a letter, June 5th, 1824, "The Constitution of most of our states and of the United States assert that all power is inherent in the people, that they may exercise it by themselves, that is their right and duty to be at all times armed," which means, as I stated, Black's Law Dictionary, anything that can be used for a defense, putting any limits on that is unconstitutional.
Thank you, Cindy. 1 second. I have one more card to read in. Matt Saxton from the Michigan Sheriff's Association opposes the bill and not wishing to speak. Rep. Hoadley, final comment.
Outstanding, and I thank your previous testimony here. It sounds like that was much more in opposition of the current statute, which is PA 328 MCL 250.227, which is the current concealed weapon law. And I would agree that we should strike a lot of the weapons laws that we have. However, we do have to operate in the world we live in, and I think you had pointed out too what this state does, what this bill would do is expands on what's already in the current law to allow more, not less. And I think we need to move that way. But I would agree if we could just strike all those laws to include being able to constitutionally carry, it's right in the name, on all firearms and knives, I'm all for it. However, we're operating in the laws in the world that we live in, and we're trying to update that, particularly for hunters and fishermen and fisher women that carry these weapons on a daily basis or other utility purposes.
Thank you, Representative. Next up, we are going to actually take up testimony on House Bill 5388 with Rep. Slagh in regards to self-defense spray. Rep. Slagh, you have the floor.
Thank you, Madam Chair. And members of the committee, thank you for allowing me just a few minutes to testify in support of 5388. I really believe it's a common sense bill. So let me help set the stage. Michigan, New York, California, Wisconsin, Minnesota, all of those have lots of shoreline. But besides that, those are the only 5 states that are not allowing shipment of a less than lethal projectiles to come in with tear gas to come into the state of Michigan. Byrna is a U.S.-based company that specializes in less than lethal self-defense options, and they have a tear gas component that they can use or that they can ship, but right now they're not able to into the state of Michigan. This issue was brought to me by a constituent who was unable to order the Byrna Max projectile for his personal self-defense use. And when my office looked into why he was unable to get it, and when customers of other 45 states are able, it was found that our law does not explicitly, there we go, allow for customers to possess a tear gas component, even in low levels. Currently, Michiganders can only use pepper spray for self-defense, which is not as effective as stopping someone intent on doing harm. So this bill, 5388, would allow for products that contain low concentrations of the tear gas chemical for self-defense and provide for penalties for the misuse of that chemical. Legislation would allow the Byrna Max and other similar products to be shipped to customers in our state, giving our citizens one more option in self-defense, and that is not a deadly force. And I'd welcome any questions and ask for your support.
I'm sorry, Representative, you may have said it, but I was reading something else. How many other states have made changes in their laws for this?
There are 45 that allow it.
Okay.
5 that do not.
Representative Minority Vice Chair Carter.
Thank you, Madam Chair. As a person who once upon a time used to have pepper spray and its misuse, have you gotten any information from the medical community about what this new compound would do to citizens or persons that are sprayed with it? It has a chemical. I saw the 8%, and I'm not going to butcher it like our last colleague did, but I'm just curious about that because I think that was outlawed at one point from somewhere, and I'll pull it up later. But have you talked to anybody at the medical community about what this new compound would do?
We did not reach out to the medical community. We did reach out to Michigan State Police, but not to the medical community.
And what was their response, if I may?
Their response was that this bill allows what they believe is a realistic amount to be able to put in, and they were not going to oppose or support the bill either way.
They were not?
They are not supporting or opposing the bill either way.
Neutral. Okay, thanks.
All right, Representative. Seeing no more questions, you're dismissed. No. Anyways, there weren't any absent members at the time of attendance. Seeing no further business before the committee today, we are adjourned.